the appellate body final forever, because if you look at final in law forever, so for the permanency until the end of the world, the subsequent tribunals will be bound.
Can I just add very, very quickly? I think what's missing from the current system, just to narrow down what this appellate mechanism would be for me, it would be to correct errors of fact and errors of law, which you currently can't do. So you can, in the ad hoc, in the ICSID annulment system, you can't do that. Before a domestic court, you can't do that. So what you don't have the ability to do is to say, well, you've got this fact completely wrong, which completely changes the analysis, or you've interpreted this law completely wrong, which changes the analysis. So that's what the appellate mechanism, I think, would do. The only question is, what's the standard? Is it like manifestly wrong? Or it would have to be high, because what you certainly don't want is a de novo review of you just get two chances at the case. Right, you just run the case again. That you definitely don't want. You want sort of a high standard so that the appellate mechanism is only looking at something manifest.
Just very, very briefly, I remember I enjoyed enormously reading 15 years ago a paper by Rusty Park that said that on his way to university to give a lecture, he saw a shoe repair shop, had a sign on the window that said, we have low prices, fast work, high quality, choose 2 of the 3. That doesn't apply to investment arbitration. You need all 3 for the system to actually have the kind of legitimacy that civil society requires of states and that states require of ISDS, and that they have in mind when they're executing bilateral investment treaties that allow disputes to be solved by arbitration. Otherwise, we're back to choosing the coin, 50% chances of winning or losing, but at least you know how you're going to win or lose.
Yeah, thank you very much. It's why we offered, together with Chile, Mexico, Australia, Peru, Israel, and some of other countries to draft the international procedural convention or any agreement, and including code of conduct, financing of third parties, and the creation of the center helping to less developed countries to participate in international arbitration and other procedural issues to this convention. And it's very useful, we think, for the states because they can join the convention in full or in some parts. And we think that we can resolve these problems by drafting this new convention. So thanks.
Thank you. Other questions? Statements? I think Diana over there, and then Sergey. I think first to the lady over there.
All right.
Okay.
Thank you. My name is Diana Malachoeva. I'm a lawyer at Bryan Cave Leighton Paisner. Thank you again for the very fruitful discussion of this indeed very difficult topics, and I think it's like there are a lot of issues to discuss, and it's kind of impossible to discuss it like right now. So my question is rather concerns a policy issue rather than the particular proposals. And the question is, so there is a view that the current crisis is mostly caused by by the factor that the states somehow like started to realize that they are sort of losing control over the system, and the system itself kind of suffers from its own depoliticized nature. And so now the states just gathered and managed to, like more than 100 states managed to like gather and to discuss, and in a surprisingly how to say meaningful way, which I think is already a big achievement for the states. And in this kind of issues. So do you think it's not the question of, it's not rather the question of the particular outcome of the discussion, but the discussion itself, so that the states, like they realize that they regain control over the system, and they can manage their, like the system of dispute resolution. And as I think Diego mentioned, they will feel owners of the outcome of the discussion. So as long as the outcome satisfies some, I don't know, minimum reasonable, there will be some minimum sort of set of measures which are reasonable and will satisfy most of states. Will it allow the system to continue to exist in the same way or in some sort of changed way, which I think like the Multilateral Investment Court does not fit into this some sort of minimum reasonable measures to take.
So I think in part the discussion itself is is successful by its mere existence, with the very limited exception of the decision on how to appoint, or who to appoint as the chair of the session. Every other decision in Working Group 3 is only adopted by consensus, and so that is strengthening of the discussion and of the development of a debate on problems that everyone knows exist. Now, it's terribly good that a consensus is created as to the existence of a dead body in the closet. But that doesn't solve anything. You have to take the body out of the closet. You probably have to call the police also. Finding that there are issues is very important, but itself doesn't solve anything unless this is just used as a veneer to keep things working the way that they were. And I think that will defeat the purpose of this tremendous effort that is being put by UNCITRAL and by the many countries that are taking resources out of their own treasuries and the time of the very, very necessary administrative bodies to try and work something out, to have Russia and the delegates from the Philippines and Israel and Chile and Peru and Mexico all develop tools and spend time and money that would otherwise be used for the many thousands of uses that every state has to cope with. The states are by definition understaffed for all the problems that may arise. That they would take resources to do this is laudable, but it only really works if a result is reached that solves, if not all, at least as many of the problems as can exist. But I agree with you that the fact that the discussion has overcome 50 years of silence in a sea of problems that were perceived as very difficult to overcome.
I believe there was a question over there.
Thank you. Sergey Tima, Russian WTO Expertise Center. You referred several times to the appellate body of the WTO. And my question is whether how the Working Commission estimates the experience of the WTO and the work of the appellate body of the WTO. Is it positive or negative? And the second thing is how the Working Commission estimates the crisis with the appellate body in the WTO. When we look, on the other side, we have the problem of the predictability of the system that we have in the investments and the bilateral investment treaties. And on the other side, we have opinions of some WTO members that state that appellate body members create far-reaching interpretations of the treaty that, let's say, they create obligations that are not written in the treaty. Thank you.
So I would like to say a few things about consistency. Consistency obviously is a value, but it is not the only value. First, because you can be consistently wrong. Second, because law has to have certain flexibility to adapt itself to changing social and economic circumstances. Another value, in my opinion, in addition to consistency, is value pluralism. The party appointing system is not the only way of achieving value pluralism, and it had mixed results in achieving value pluralism to a certain extent because the stakeholders, the actors in the system, which includes the states, have appointed the same individuals or a very limited number of individuals in many cases. Now, the same states that appointed repeat players as arbitrators now complain about repeat appointments. So I agree that this is a problem and this needs to be fixed, but I'm also concerned about how to achieve value pluralism in any potential investment court system, because I think this is important. Thank you.
Thank you. I can give the mic over there.
Igor Chelikov. Hi, everyone. Very nice presentations, and very good discussion after that. There are a lot of issues which I wish to reflect on, but I will probably cut myself just on two. The one thing is that I think there have never been an international court which everyone would be satisfied with. And say the compulsory jurisdiction of ICJ has been open for adherence for like many years, but I guess like how many, 40 states or 40 something states have chosen to accede to compulsory jurisdiction of ICJ, and I think that's telling a lot about the willingness of the states to assign some of their sovereignty to a standing adjudicatory body internationally. That's one thing. The other thing is about consistency. I really liked the comparison with the teenager. But I think the teenager is not the court system, let's say the ISDS court system itself. The teenager is the international law, or its particular part, the international investment law, which we're dealing with. And like for me, many of the inconsistencies which we are facing are just a result of the awake definitions which the states have been using in the first and second generation of the investment treaties, for good or for bad. Like for some it really attracted some investment, for others that was like a result of their successful negotiations, like who knows. But the solution for this probably lies in greater part in amending, if the states are not satisfied with that, in amending the material standards or the actual content of the BITs they're working with, rather than on trying to provide a good court for a bad law. Thank you.
Thank you. Any?
Yeah, no, I just to pick up on your second, I think that's absolutely right. It's the law that's the teenager. The system is a commercial arbitration system that's been working for a long time. One thing that always, and so sorry, just to finish up on that point. So in a way, changing the system doesn't change the teenager. The teenager stays. It's just the system that doesn't change. I think that's an excellent point. The other thing I would come back to the young lady's question, which is, you know, is it great that they're all coming together and talking about this system? What always strikes me is it is their system. Right, the system is out of control, but it's your. I always tell the states when they say, "Oh yeah, but it's a bad system." It's your system. You know, it's not as if someone foisted it on you and said, "Hey, guess what? This system applies to you." No, someone somewhere at some time signed documents that said, "This is what we're going to do," and so you know, this notion, in a sense, that states are put upon by this overwhelmingly banned system. It's their system, and what always strikes me is the states who don't think about it critically, but rather just say, "Well, the system is broken," but then they never do anything about it. You know, they never come out of BITs. They stay in the same BITs. Now we're seeing, when we saw denunciation, we saw the EU now interstate BITs are coming out. India has started to take action. We are seeing now more than just complaints. And that, I think, is good. But I would still come back to the point where this is your system.
Just very briefly, I remember I was somewhat surprised to read the first paragraph in one section of the award in Sabshab Shum v. Peru. I don't know what the parties were disputing, but the award goes out to say, the issue of the most favored nation treatment arises in 13th century Central Europe. How was that relevant to the questions that the parties may have? That's completely obscure to me, but that proves the point that MFN has been there for 800 years. I was this week actually, I was in Islamabad for work, and I ended up at the office of the Law Minister of Pakistan, awaiting him for a meeting, and there was hanging on his wall a copy in English of the Medina Charter that was signed by the Prophet Muhammad 700 years ago, roughly, and it contained language that we would call substantive standards of protection under international law, including standards of expropriation, national treatment, most favored nation treatment. That has been there since the dawn of international law. Before Émeric de Batel put a single pen on a single piece of paper, these principles were there already. What's new is that we have individuals making the claims, private lawyers putting those claims together, and groups of three that many times come from the wrong area of the legal training, to be very euphemistic, adopting those decisions. I would think there's nothing terribly new about the law itself. Most of these provisions are reformulation of things that existed in the Friendship, Commerce and Navigation treaties of the early 19th century. The Argentina-US Friendship, Commerce and Navigation Treaty of 808 was very similar in, I'd say, 75% of the provisions to the Argentina-US BIT of 1992. No one would expect that decisions like the 40-plus awards that came in the wake of the 2003, 2004 cases against Argentina would be issued under those languages. But I think it's many things have to be improved, but if there's something that is surprising, it's not the language in the treaties as much as the language in the decisions. And by the way, we're getting 500-page decisions from five-page treaties. So I think that most of the novelty comes from the drafting. I do agree with one of Badger's first remarks, that is that we need to have a page limit, but we need to have a page limit for the awards too. And
I think if I, again, could just add a bit to that, because I think maybe the standards are the same, but the additional issue that arises when you transpose the standards from national law to international law is, while the standards may be the same in different legal systems, their understanding of the application in individual cases may be very different. So what would be considered a taking under, because expropriation, yes, existed for ages in every developed legal system, but what would be considered taken in each legal system when you come to regulatory action could be surprisingly different. And I think when you dealt with the European Community of Nations, espace juridique, which have more consistency in how they approach this difficult administrative law questions. You had less surprises, but when you have a global system, and when you, I think that comes back to who are the arbitrators and why diversity is important, because when you get people, all of them trained in a certain legal system or a certain legal tradition, they may transpose their notions of administrative law, essentially, and fairness and administration of public offices, etc., and that may come as a huge surprise, and that may raise concerns. Then I was always the page limits and how this operates is I think issue that is mentioned with increasing frequency, and in this respect I remember there are so many already existing examples of the appellate body. The international criminal tribunals have for a number of years had page limits, and I remember one of the appellate chamber's decisions, which was that there was a page limit, and then one of the parties adjusted the formatting thus that even though the font appeared to be as required, it was actually smaller, and so the other side kind of using a ruler determined that the font was actually smaller, and they kind of, with a proper font, they ran out of the page limit, and so they had an argument, and they had a separate appellate chamber decision on the proper formatting. So that issue creates a next layer of litigation for us to deal with.
Thank you again. So I would like to proceed a little bit more on the issue of the finality of the prospective appeal body, which we have tackled already. Because when I'm thinking about a world where there is an appellate body, separate appellate body, which exists without any multilateral court as some kind of body on top of the current system of investment arbitration, then the question is, do we really need finality within such a system? Because it totally leaves us without any incentives to go and enforce the award of the first instance under the New York Convention, because we have an option to go to the appeals body and to have a final decision instead of going under the New York Convention to each and every state and enforcing it. Therefore, the possible conclusion would be is that we need to work for the appeal body. We need it also to be within the frame of the New York Convention. Otherwise, every investment case would be going to the appeals body. Do you kind of agree with this logic or no? Do you need it to rephrase?
But I think it depends what the appeal body does. So in a sense, I could imagine a system where the investment tribunal stays vested, it's not functus, and you go to appeal, and then an appeal can send it back to the original tribunal. That's one choice, and therefore then you go to a domestic court for New York Convention. Only if you vest the appellate body with powers of revision, revocation, adoption, absolute power of rendering what is essentially a new award. Again, I think it will depend on, is it an appellate body decision, or does it go into the award, do things in the award? So it stays an arbitral award. It's just been amended, I guess, by the appellate body. Then it still would, for me, stay as a New York Convention arbitral award, which you can then take to the court. So in other words, I don't necessarily see it as extinguishing, going to the appellate body as extinguishing either the right or the desire to keep the domestic court oversight, but it would be different functions, of course, because the domestic court oversight under the New York Convention is completely, for example, public policy. I don't think would be something that the appellate body would address. So that would be something that would be kept at the domestic level, in my mind.
I totally agree, and I don't want to add anything on that regard, but I want to address something fundamental, because I think that the observation that these international standards have been pretty much there since hundreds of years, I think it's very true and it's very important. So what's the difference? The difference is that these standards were not always enforced. Why? Because states, for diplomatic, political reasons, rarely took up at the international level claims of their nationals, and when they did so, they didn't always do that peacefully. So obviously, taking example, for example, Latin American states in the 19th century, the standard, the law was the same. Don't expropriate without public purpose, without providing full compensation, without discrimination, etc. The standard hasn't changed. The only thing that changed is that in case a Latin American state does that, there is no British warship that goes to Latin America. There is an exit proceeding, which is not perfect, but I think it's preferable from what happened 100 or 150 years ago.
I think the fact that ISDS has, for the last 50 years at least, or probably even 100 years, looked very much like commercial arbitration, is troublesome in this respect, in that it has created in many of the actors the perception that the purposes of commercial arbitration and investment arbitration were the same. However, and my colleague to my left will correct me on two levels. One, because I'm going to cite from a letter from the Tsar of Russia, and I speak no Russian, so maybe what I say makes no sense. But that's the letter of Nicholas II, which invited the participants to the Hague Convention of 1899. And the purpose, and that's of course the instrument that ended up creating the Permanent Court of Arbitration. And the purpose of that was not distributive justice, was not rapid enforcement of pecuniary awards in the format of Article 54 of the ICSID Convention, but the object of seeking the most effective means of ensuring to all people the benefits of a real and lasting peace, and above all, of limiting the progressive development of existing armaments. This has been, even with all of the problems that investment arbitration has developed in the last 50 years, this has been rather successful. The kind of war confrontations that have flagrantly developed from investments having been affected has diminished, has not vanished, but has diminished. And I think that was and still remains the primary purpose of investment law as a part of international law. And we should be careful not to lend ourselves to interpretations that are perfectly appropriate for commercial disputes, but do not very easily or accurately apply in the context of national law. This is probably the main reason, and we may have just taken this stance instinctively, but this is the reason why the choose 2 out of 3 adagio of Rusty Park applies to commercial arbitration, but does not adapt to investment arbitration. That we need all 3 tenets, that we have a good decision that is issued at a reasonable price, and that is sufficiently useful that the community can live with it, and whoever felt that its rights were wronged can actually live with the results. And the reason is that we're not about giving to each its own as fast as possible to go back to business, but to maintain the peace. And I think that is something we cannot quite lose from sight.
I think we've been agreeing on the panel all night, so I'm going to disagree with both Diego and Mikhail. I think those days are gone. You used to have the reason that we protected foreigners and foreign investment was that it took a long time to move money from one place to another. It was very difficult to move domicile or incorporation or money from one place to another, and you welcomed foreign investment. And usually in those days it was colonial times, you would have the colonial power into development power, hence the warships. That's not today. Today, you get corporations, you can look at them, you don't know where they're from because they are multinational. Having worked at a US corporate law firm, I get and I'm sure you have this here, you look at the way that these companies are organized. They are not an American company or a Russian company. They are in Cyprus and BVI and holding companies in Gibraltar and down here and over there. So to the notion that for example, the multinational company will use a holding company in Cyprus to sue the state. The idea that Cyprus will take up an espousal of the claimant of a holding company, I think is true. I would also say the majority of cases in investor-state arbitration are small to medium-sized enterprises. So the idea that they are going to lead to a lack of peace because Mr. X and his hotel that got raided, the government is going to take a warship for that, is very unlikely. You are talking about, I think, a sliver, the top quarter of a percent of very important enterprises that a government would today espouse with all the other things going on, all the other conventions and all the other treaties that they have in place. So that paradigm of we need to have peace and therefore the investor-state system promotes peace, I think those days are gone. So I would come back to the question, which I think states really should be asking themselves is, if we don't have an ISDS at all, will that change foreign investment 1%? I have to say, I'm not sure, because there is very little literature connecting ISDS with promotion of FDI. Why do people invest? They invest to make money. Brazil is a great example. People invest in Brazil, no BITs, you know, and so I have to question why you need the system at all. I think the invocation of peace is a paradigm that existed in Muhammad's time, but I'm not sure it exists today. Right.
I'm not going to disagree so much about the peace. Hopefully, you are right. But I would like also to address the issue that corporate disputes have a link with the states because of the polycentric and anarchic way that modern 21st century capitalism is working and is structured. And this might be true, but it's not always true. And one can look at a purely state-to-state dispute settlement system of economic disputes, and I'm referring to the World Trade Organization, and there we have disputes between the EU and the US about subsidies given to Boeing and Airbus, and I think the link between these two companies and these two states
that I was acting as a delegate for, to exercise diplomatic pressure regarding cases that were ongoing. The last case that we held a sovereign client settle. We settled at meetings that were conducted with someone who showed a power of attorney executed by the individual owner of the claimant company and the president of Turkey. Same piece of paper signed by Turkey and a Turkish company. And the respondent state, everything is public nowadays, so was Pakistan, which has, of course, a very long-lasting and very deep diplomatic connection with Turkey. And the fact that the president of Turkey had signed a power of attorney together with an individual claimant had a strong bearing on what the dispute settlement procedure would look like. And that was actually the reason why the case was eventually settled. So one cannot, I do agree, of course, with Badger that there's a number of smaller claimants or smaller claims that are not entirely within this understanding of whether they affect peace, but also there is a requirement in Salini of a certain materiality